I'm Lori Critt-Martin, the Vice Chair of the Beverly Hills Bar Association Litigation Section. I'm delighted to introduce you to today's speakers, Paul Kiesel and Melanie Palmer. Paul Kiesel is a managing partner of Kiesel Law. His practice is devoted to representing consumers in personal injury, class action, environmental, and toxic tort litigation. Mr. Kiesel has repeatedly been selected as one of the top plaintiff attorneys in the state of California and the country. The Los Angeles Business Journal recognized Mr. Kiesel as one of the top 50 lawyers. The Daily Journal named Mr. Kiesel as one of 100 most influential attorneys in the state of California. He has also been selected as one of the top 500 attorneys in the United States by Law Dragon. Melanie Palmer joined Kiesel Law LLP in 2014. Her practice focuses on mass tort litigation, pharmaceutical, medical device liability, consumer class actions, and catastrophic personal injury. Ms. Palmer was recognized as a Southern California Rising Star from 2019 through 2022 and a super lawyer in 2023. She has tried 8 jury trials to verdict, including a 4-week product liability trial in which the jury awarded her client $6.18 million and this client was a single plaintiff for the life-altering injuries that he sustained. And now let's get started with today's lunchtime program. Take it away.
Perfect. Wow. And I almost shut you down because it went like 2 seconds too long, but you ended before I got to do that. So thank you for the introduction. Happy to join the Beverly Hills Bar Association for today's program. And Melanie, why don't we start a second by identifying what's the name of the program? Melanie, why don't you pull up your slides so you can look at the name of today's program?
Pulling up now. Do we see them here?
Okay, so it says, how do you get those punitive damages? It doesn't say damages. How do you get those punitives? The truth is, what it really should say, and what our panel today is about, is how do you keep those punitive damages? Because sometimes you get them, and you have a hard time keeping them. So a lot of what we're going to talk about today is how do you keep those damages if you're fortunate enough to get them. Sorry, back to you, Mel. You're going to run the ship today.
Yeah. Okay. So first we'll start by talking about the legal standards and definitions. And some of this is I'm sure everyone knows, but let's do a little refresher. Okay. So the jury may award punitive damages where it's proven by clear and convincing evidence that the defendant has been guilty of malice, oppression, or fraud. And malice is despicable conduct with willful and conscious disregard for the rights and safeties of others. Oppression is similar conduct causing cruel and unjust hardship in conscious disregard for the plaintiff's rights. And then fraud, of course, is the intentional misrepresentation, deceit, or concealment of a material fact known to the defendant. And, just as a reminder, when you have a corporate defendant, you really need to keep in mind that you have to prove a managing agent or director knew or ratified the conduct. Okay, so we'll talk about this a little bit more specifically as the presentation goes on. Okay, so before we jump into our tips and recommendations for working up your case, not only through discovery, but trial presentation, we need to discuss, as Paul said, how do we keep punitive damages, right? And so part of our discussion, a significant portion of our discussion, has to do with constitutional considerations that the courts will analyze when determining whether a punitive damage award is excessive. So said another way, we're really starting our analysis at the ending, our ideal ending of upholding a punitive damage award. So we're going to work backwards to make sure you end up where you want it to be, where you want to be. Okay.
To step back even further, right? Today's presentation is going to talk about, number one, when you're going through jury selection, when you're looking to pick your jury, what are you looking at with regard to a punitive damage award downstream? And then if you achieve that punitive damages award, what are your limitations that you must comply with in order to prevent losing those award awarded damages or keeping them. Go.
Right. So on that point, to keeping our punitive damages, right? So to securely or to truly secure a punitive damage award, one that would survive appeal, we need to understand these constitutional factors and be guided by them during our pretrial workup and our trial presentation. So the California Supreme Court and the US Supreme Court have been very clear. A punitive award is arbitrary and violates due process where it is grossly excessive in relation to the state's legitimate interest in punishment and deterrence. So if you want punitives, you need to stack your evidentiary record to these key factors. And these factors are what's going to drive our presentation today. So the first factor, I have them all laid out here and I'll just briefly touch on them. The first factor, and this is the most important factor that the courts weigh, is the reprehensibility of the defendant's actions. The more reprehensible the act, the greater the appropriate punishment, assuming all other facts are equal.
So that's maybe a good way to describe that would be to look at the O.J. Simpson example of the egregiousness that the jury found, that civil jury, and awarding punitive damages, perhaps murder, is the most reprehensible of actions a defendant can engage in. And therefore, the prism the jurors and the court are going to look at is, if it's murder and you found it's murder and you're going to award punitive damages, that is perhaps the worst type of conduct that would allow an award of punitive damages that would not be, open quote, grossly excessive, but we'll talk about that in just a second.
Right. So, well, like going to Paul's example of murder, clearly reprehensible, right? The most heinous of crimes. Sometimes we're not dealing with defendant's conduct that's not so obvious. So it's important that your case workup establishes the evidentiary record you need to later justify a substantial award. So we'll go into discovery more specifically about that, but reprehensibility. The second factor is the relationship between the amount of compensatory damages versus punitive damages. This is where your workup and understanding of the plaintiff's damages really come in. And the US Supreme Court has rejected the imposition of any rigid benchmark or any set mathematical formula for actually establishing an approved ratio between actual and punitive damages. But the court—
Yeah, that's a yes or no. I mean,
Yes.
they've gotten away from this is not an unlimited field that we're playing in, and we'll talk about that today. But there are limits in terms of the ratio of compensatory versus punitive damages. And what are compensatory damages? How do you evaluate compensatory damages? Well, just like in a personal injury case, it would be general damages versus special damages. Special damages are going to be medical expenses, lost profits, loss of income. That's going to be your special damages. And compensatory would be your general damages in terms of your pain and suffering, the loss of love and companionship if it's a wrongful death case. And that's the damages side are special and general damages on the compensatory side versus the punitive damages on the other side.
Right. So Paul's perfectly right on that. So the courts have not set a bright line rule of what ratio is appropriate, but they've been very clear that ratios significantly greater than 9-to-1 are suspect and generally cannot survive appellate scrutiny without special justification. Okay. So said another way, courts have regularly said few awards exceeding a single-digit ratio will satisfy due process. In fact, many courts have said a 1-to-1 ratio is appropriate in cases where it's low reprehensibility conduct and substantial compensatory damage awards.
So can you give us an example, Melanie, what that would look like? What does that mean?
Yeah, so sure. So, and this goes back to what Paul was talking about compensatory damages. Compensatory damages are not treated equal when the court is considering this ratio. So, for instance, courts have upheld higher ratios when they're egregious acts with small economic damages. And in a case called Nickerson v. Stonebridge, the courts upheld a 10-to-1 ratio, which is significantly high, right? It's on the upper scale of what would be reasonable under the due process clause.
Do you know what the compensatory damages were that were awarded in that case?
Yeah, it was 35,000 were the compensatory damages. So the punitive damages ended up being
$1,000, right? So it's 35,000 versus 350, but
Right.
it's low compensatory, but a substantial, arguably punitive award.
Right. And then on the flip side, the courts have given lower ratios when non-economic damages are substantial. So for instance, in the Roundup litigation, where the juries awarded millions of dollars in compensatory damages, the higher courts upheld much lower ratios. So in California, there have been 4 cases that went to verdict successfully for plaintiffs. And the first one, the Johnson case, the higher courts upheld a 1-to-1 ratio. And in the Hardiman Monsanto trial, 3.8-to-1 ratio was upheld. In Piliad, there was a 4-to-1 ratio upheld. And that's because we're talking about significant non-economic awards, and then the court then used a lower ratio. The notion that higher non-economic damages warrant a lower ratio, and I was really interested by this, so I researched it further and tried to understand why the court will give a lower ratio when non-economic damages are involved. And generally, in regard to this issue, the courts have explained that substantial awards for pain and suffering may innately contain a punitive element based in part on indignation at the defendant's conduct. So according to the courts, they say that these higher substantial pain and suffering awards therefore serve as a deterrent in and itself, and then justify these lower ratios. So really,
another way, when I've tried cases where punitive conduct has been at issue, I have found that the jury awards sometimes significantly more general damages to the plaintiff or their family than might otherwise have existed had there not been punitive conduct that's occurred. So the punitive conduct, even where there's been a bifurcation, we'll talk about that in just a minute, but even where there's been a bifurcation of general damages versus punitive damages, there are still issues that will inflame the jurors, but they're still not based upon passion, prejudice, or sympathy. They're still looking at the evidence, will tend to award a higher amount of general damages where punitive conduct is alleged than even before you get to the punitive phase of the trial. And I think that's what your research bore out, right, Mel?
right, exactly. Okay, so let's go to the third factor, the difference between the punitive damages award and any civil criminal penalties authorized or comparable or comparable, depending on how you say it, in comparable cases. So this factor is more relevant in labor law actions, business code violations, or maybe even in conduct involving physical acts of aggression where criminal penalties could be involved. But in the product liability space, this analysis is more focused on comparable claims and injuries with the same device. So, pick your mass tort litigation where there had been trials where punitive damage awards were rendered by juries. Subsequent trials will point to the other juries' findings and whether those findings were upheld by the higher courts. And the fourth factor that we are really going to focus on too is the wealth of the defendant. This is not a factor that was identified by the U.S. Supreme Court, but it's been one that is very much discussed in our California case law. So it's very important to keep in mind. An award of punitive damages cannot be sustained on appeal unless the trial record contains meaningful evidence of the defendant's financial condition. So it is the plaintiff's burden to introduce this evidence of the financial condition. And you have to keep in mind, the courts are really concerned about these runaway verdicts. And the mantra that they have for this is that the purpose of punitive damages is not served by financially destroying a defendant. The purpose is to deter, not to destroy.
It's
But on the
funny,
other,
as you're talking, Melanie, it reminds me, it just hit me. There was a great Jerry Spence trial that I read about in his book 30 plus years ago. It was where I think her name was Karen Silkwood, who got radiation poisoning from Kerr McGee. And he referred to radiation as the lion. So his theme was, if the lion gets away, Kerr McGee's got to pay. That was his theme. If the lion gets away, Kerr McGee gets to pay. But he talked about a paper boy. And if the paper boy every morning hit you intentionally in the face with the paper every single day, but the paper boy got $10 a week. If you only took like a penny from the paper boy, it wouldn't deter him from hitting you in the face with the paper every single day. But I think he said but a nickel would, or 25 cents would, in comparison to what his income was, to justify making an award of damages. This was before the Supreme Court set standards on what grossly excessive numbers were. He was trying to take the wealth of the defendant. In this case, it was a paper boy, how much he was earning each week versus how much money he should pay out of his own pocket to deter him from engaging in that conduct. And so the wealth of the defendant does play a role in having an award of damages that's high enough that the defendant's going to feel the pain of the punitive award, right?
yeah, exactly. I mean, that's exactly a great segue, because a punishment is ineffective if it is not felt, right? So whether the message intended by a punitive damage award is felt hinges on this particular defendant's financial condition. And I will say, based on my review of the case law, this is an aspect that I think can be developed more when the cases are right. So even in the Monsanto situation, where the defendant is a multi-billion-dollar corporation, it needs to always be emphasized that if you reduce to certain lower ratios, then how is that going to be felt? Okay, so with these constitutional factors in mind, we're really going to focus on the first two and the fourth, and how we need to keep those factors in mind as we not only go through discovery in a case, but also present evidence at trial. So a few nuts and bolts: case evaluation. Early evaluation is critical because not every case qualifies for punitive damages. First of all, keep in mind, if the primary source of recovery is insurance is not going to cover a punitive damage award.
Why not? Why doesn't insurance cover that?
Question for me? Well,
Yes, that was true. I can't. It's just you and me. There's no one else here.
Yeah, well, because the insurance does not cover intentional willful misconduct, and that's exactly what punitive damages is.
Got it. Thank you.
Okay. See, Paul always has a Socratic method. I should always be ready. Okay. So the common cases that we usually see punitive damages in involve obviously willful misconduct. So think assaults, batteries, DUI crashes, intentional infliction of emotional distress, wrongful termination, premises liability, product liability, and also insurance bad faith. So what you really need to do is look for patterns that suggest repeated and willful misconduct. So think repeated violations, ignored warnings, and reckless regard. And really, this goes to the ratio. You need to consider your plaintiff's damages. What are your plaintiff's damages? What are you going to prove? And how are those ratios going to play out? And periodically throughout the case, obviously, you're not going to know much until you get through discovery. But as discovery unfolds, you need to weigh the evidentiary strength, because later on, and Paul will talk about this, you don't want the jury to think you're overreaching, because if you're overreaching for some things, it's going to suggest maybe that you're overreaching to the jury. It's going to suggest you're overreaching on other things. So, and you don't want to lose that credibility. So plead with specificity. Courts will always scrutinize vague or boilerplate language. So Amend early if you need to, if you don't have the facts just yet, and anticipate demurs and motions to strike. No insurance carrier is going to agree for leave to amend to add punitive damages. Take this opportunity as a way to educate the court on the importance and severity of your case.
Said another way, sometimes you might not want to plead punitive damages at the outset because you want to develop an evidentiary record that supports an amendment to include a claim for punitive damages, because the level of specificity you need to overcome a motion to strike or a demur is substantial. So to the extent you have enough facts to allege punitive damages, I'd say you do so, because that'll give you even more opportunities during discovery to get additional information. But to the extent you don't have a clear enough record to initially plead a claim for punitive damages, that will not prevent you, obviously, from filing an amended complaint to include punitive damages and allow you to get the discovery that you're going to need, either directly from the defendant or from other sources that you'll put together to amend to include a claim for punitive damages in the future.
Right. So about that, with strategic discovery, right, you need to use your discovery kind of precisely. You're not just proving bad behavior, you're really proving the defendant's mindset here. So you need to establish that the defendant's mindset by building your evidentiary record. I mean, this really goes to factor one, the reprehensibility of the defendant's actions. It's not just the bad stuff that they did, it's about how they knew they were doing something wrong and chose to do it anyway, often for profits or whatever margins that they are trying to uphold. So in determining the reprehensibility of the defendant's conduct, the court will consider many factors, but more relevant to our discussion here, one is the defendant's indifference to or reckless regard of human or the health and safety of others. And second, if the conduct involved repeated actions or was just an isolated incident. And then third, whether the harm was the result of intentional malice, trickery, deceit versus an accident. So here in California, intentionally marketing a defective product, knowing that it might cause injury or death, is highly reprehensible. So repeated misconduct is also considered more reprehensible, and evidence of great profit also may be relevant to showing a greater degree of reprehensibility. So those are important things to keep in mind. You really want the inner workings of the corporation. So in terms of discovery, think of their internal emails, internal policies and procedures regarding testing, their internal reviews of testing reports, relevant scientific literature, the company's review of that literature and what was done in response to that literature, complaint history, prior similar incidents, and more importantly about the prior history and prior complaints, what was done after that? What corrective action reports were created and what actual actions were taken after these prior complaints?
And how high up the corporate food chain do all this go? Because if it's all done at a low level, even if it's a record in the discovery, but it doesn't show it's risen to the point of being an officer or a director or someone who's got the ability to ratify the conduct, it may be punitive behavior, but it's not going to get the corporation on the hook for punitive damages.
Right, exactly. Exactly what Paul just said. We need a managing agent who knew or ratified that conduct, right? So you need to find out who was in the room when decisions were made and depose those agents early. Again, this goes to the reprehensibility of the defendant's action, right? So a common issue that comes up in the case law is that the plaintiff simply refers to the corporate defendant as it or they, without specifically identifying or linking the conduct to a director or agent. So you don't want to fall into that trap. You need to use PMQ depositions effectively to establish what the company, through its agents, specific agents and directors, knew, did, and didn't do. So this really involves getting or identifying the right individuals early. So get an organizational chart, find out who was in the room or who was responsible for making the ultimate decisions. So common PMQ topics here would be, again, safety and testing and training, prior complaints, employee personnel files, like who's responsible for maintaining that and who can talk about an employee's personnel file, because oftentimes personnel files can establish prior knowledge of a particular employee's unfitness, for instance. And that's imparted to the corporation. And then key too in a lot of our product liability cases are policies and procedures for evaluating and approving marketing claims. Okay, great marketing claim, it's safe, great for XY user. Well, was that run through legal? Was that run through research and development? How was marketing able to approve this claim? Is it backed by science? Is it backed by the law? Is it backed by any of the reasonable measures that we think a responsible corporate defendant would take when marketing a product?
By way of example, we were co-lead counsel in the Juul e-cigarette litigation. And when we get into the discovery of what they did to ensure the safety or efficacy of vaping e-cigarettes, it would not shock you that there was a lack of a true protocols followed to establish the safety for a product that they were selling as being a healthier alternative to combustible cigarettes, which is a broad statement because combustible cigarettes are like the most dangerous things you can have in the world. They're cancer-causing agents. But that's not to suggest that inhaling liquid nicotine that's been superheated deep into your lungs is a safe behavior. And so when you get into what they actually did to determine the safety of that, you might find there was an absence of any true studies to determine the safety of that conduct. Didn't go to trial, but that would have been an important issue had it gone to trial with regard to what was done to determine the safety of electronic cigarettes.
Right, and to Paul's point, I mean, when you really start peeling the onion on these issues, so for instance, in Juul, depositions were had, and we were starting to realize there really wasn't a mechanism for safety, and that you will find too if you start really peeling the onion on your defendant's corporate structure, how things are run, and maybe they have core values and mantras, but how are those upheld? When you start really questioning, then you'll find the fodder for a potential punitive damage claim if it's there.
So just remember, your PMQ categories need to be very broad, and you can have lots of them. Remember, it doesn't have to be one person. You can have a person most qualified notice that has 25 different subject matters, and they may need to produce 25 different witnesses that address each of those different subject matters, but be as broad as you can in the PMQ notice to make sure you cover all the categories you need to establish your claim.
Okay, so the next step in our analysis is really establishing defendant's net worth. So this is the fourth constitutional consideration that's really been highlighted in the California case law. So the California—
Let's start by identifying one particular problem is you can't really do net worth discovery during the underlying case that you're handling. Because until there's been an award of punitive damages, you can't find out how much money they have, how much money they earn, how much money they've got. Unless they're a public corporation, you can't do that discovery traditionally until after you've gotten a punitive damages award to then find that information out. Sorry, Mel, I took the thunder from you.
No problem. Actually, that's the next slide. So we can jump to that because that's a very good point. So we're looking at CC or Civil Code 3295, right? That's a limit and protection concerning the discovery and admissibility of a defendant's financial condition. So that's a long way of saying a defendant's financial discovery of a defendant's financial condition is permitted only once the court finds a substantial probability of success on the punitive damage claim. So the point here is you can make this motion early and uncover their their financial condition, or you could also uncover public documents or stipulations from counsel. Ultimately, it is your burden. And so let me go back to the constitutional analysis here. But the California courts are really clear that an award of punitive damages in California cannot be sustained on appeal unless the trial record maintains meaningful evidence of the defendant's financial condition. So in light of the fact that we're not allowed to do the discovery until we get a court ruling, well, what does that mean for us? It means we need to be proactive, right? And there are ways to get information regarding the defendant's financial condition outside of just discovery. For instance, we can retain experts, right, to do business evaluations of the corporate defendant. There are public filings. So the 10K filing for any publicly traded corporation plus Secretary of State filings have been noted to establish whether a particular defendant owns certain assets. Commonly in our product liability cases, there are stipulations that will be entered into because, you know, when you're dealing with a large recognizable defendant, it's clear that there's substantial company with substantial means behind them. So stipulations are a little bit more easier to obtain from counsel. And
But to be clear, it could be a situation where you go to trial, they bifurcated liability damages for punitives. And when you get the award, you actually need to take a recess from the trial, which I've done, to engage in the punitive damages discovery that you now are entitled to do. Because the jury finds punitive conduct. Once the jury's made that determination, you now have the opportunity, if they haven't stipulated to what their net worth is, and there's no independent information you have, you actually then have to do discovery to figure out what their net worth is. And you can actually engage in depositions post initial phase of trial before you get to the punitive damages phase to acquire this information. Not desirable, but sometimes necessary.
right, and oftentimes, especially in the bifurcated scenario, plaintiff's counsel will subpoena, right, just using CCP 1987 to subpoena the production of financial records and witnesses at trial. So the CFOs or accountants of the corporate entity. So there are ways to ensure that you have the record you need. And now that you understand like the limitations around actually getting discovery, let's talk about what discovery you need to get ultimately, okay? Commonly, net worth is the most used measure for determining a defendant's financial condition, but it's not the only measure in determining whether punitive damages are excessive. Net worth typically works with most corporate defendants, but it can be adjusted to include depreciation, which represents a loss for accounting purposes, but doesn't impact the defendant's actual ability to pay. So going back to Paul's example about the O.J. Simpson case, in the civil case, the Court of Appeal actually upheld the punitive damage award of $25 million, even though it determined that Simpson's estimated net worth was $15.4 million, so almost $10 million less. His net worth was $10 million less than the punitive damage award. But the evidence demonstrated that the defendant was a wealthy man with prospects to gain more wealth in the future. So that damage award was upheld.
And I think just to drive a finer point home, because when you hear someone's got a net worth of $15 million and gets a punitive award of $25 million, the first thing that you think of is, well, then you're bankrupt. And doesn't a bankruptcy filing then eliminate your claim to punitive damages? Mel, can I file bankruptcy if I get a $25 million punitive award against me?
You can, but I believe that punitive damage award is not dischargeable in bankruptcy.
Exactly. Thank you.
Yeah. Same with restitution orders. So when you do willful misconduct, then you cannot use the bankruptcy system to evade or avoid your responsibilities.
Well, and look, restitution, which I know you've got a really subspecialty in. Let's take a moment to talk about what restitution is in the criminal context versus a civil award of damages, because I think that plays into punitive award. How does that work, Mel?
Well, restitution in the criminal context, and just for everyone's background, I was a prosecutor before coming to Kiesel Law, and restitution awards victims the economic damages they suffered as a result of being a victim of a crime. So it's a little bit different in that, yes, they're victims of a crime, but the California Constitution awards victims restitution for the actual economic injuries that they incurred. It's not tied to the punitive conduct of the defendant. Yes, he's or she is found guilty for the crime, but it is very much tied. So I would say it's more of a compensatory recovery.
But you can't file bankruptcy. If you get a restitution award, you, the defendant, can't file bankruptcy to avoid the payment of restitution, right?
Right, exactly.
Perfect.
And like going back to abilities to pay, right? Net worth versus ability to pay. In a case called Zaxis, the Court of Appeal affirmed a punitive damage award of $300,000, where it was shown that the defendant's net worth was negative $6.3 million, because the evidence, which included financial statements and CFO testimony, showed ultimately that the defendant had the ability to pay the award. So what does this mean? In the context of the defendant's ability to pay, these cases really teach us the importance of discovering information about the defendant's broader financial picture, both retrospective and prospective evaluation. So let me break that down. The retrospective evaluation in the context of a defendant's ability to pay would include analyzing things like a defendant's attempt to secure credit and loans. Okay, this is a source of documents that where the defendant is portraying its financial condition in the light most favorable, right? And plus, any substantial lines of credit also show that a lending institution has already made a determination that this particular defendant is capable of paying back substantial sums, perhaps even in excess of the punitive damage award. And this is analysis from case law, right? So, and as to a prospective evaluation, this is like OJ. You have to look at things like the defendant's future anticipated stream of income. So similar for corporate defendants, what their viability is as a corporation cannot be disregarded, because that is really going to be your strong footing in establishing a higher ratio of punitive damages to compensatory damages. So really, the bottom line here, and Paul, I know you want to jump in, so I'll let you jump in. The bottom line is earnings reports, profit reports may not be sufficient alone. You need to develop a record of their assets, their sources of income, and their liabilities. Paul, do you want to jump in?
No, I enjoyed that. Thank you.
Okay. So, we've talked about the OJ case where, and that Zaxis case where the punitive damage award exceeded the net worth. And there is a line of cases that discuss the net worth ratio. So I think it's important to mention. These cases are literally older than I am. And they suggest that punitive damages should not exceed 10% of a defendant's net worth. But again, there's no bright line rule here. Clearly, there are cases when the facts are appropriate, warrant punitive damage awards in excess of a defendant's net worth. So if someone argues, or in a motion, that's still good law, that this 10% should be a general limit. Those are still cases that are good law, but keep that in mind. The modern case law has evolved to focus more on the defendant's financial condition. And we had already covered this, the limits and protections of Civil Code 3295. Again, make those motions early. If you have the evidentiary record to explain that there's a substantial probability of success on your punitive damages claim, make your motion, educate the court, and get your discovery early. You can rely on CCP 1987 to subpoena documents and witnesses for trial, but there's always a gamble there. And, in terms of jurors, if you're going to have a bifurcated trial, phase 1, phase 2, it's nice to be able to quickly transition rather than to either take a hiatus or to do that additional discovery.
So let me just say, it's really going to be on the defendant to affirmatively request the court to bifurcate the trial. Plaintiffs are probably not going to want to ask for bifurcation. So the defendants are going to be the ones who want to bifurcate the trial first on damages and then on punitives. And they'll want to get a finding of punitive damages before they go to the punitive phase. Doesn't always happen that way. For example, in our Monsanto trial and Roundup, they did not bifurcate the trial. We went right through the whole trial and we didn't need to worry about limiting the financial information in the underlying case and waiting for the second phase. It was all done in one phase, but that's not typical.
Okay, and then Paul, you want to take it away with trial themes and trial development?
Sure. So let's assume for a minute that they bifurcate the trial. They have a trial, the defendants have made a motion pre-trial, they want to bifurcate liability from punitive damages. They want punitive damages to be a separate phase of the trial. Does that mean when I'm doing voir dire that I can't ask the jurors any questions about their feelings with regard to punitive damages? And Mel, you're
Raise
shaking
my
your head.
hand.
Does it?
No,
Why not?
because if punitive damages are ultimately going to be at play, you have the right to question and voir dire the jury or potential jury on those issues.
Exactly. In other words, there is not going to be a separate trial with a separate jury that makes a determination on punitive damages. So I've got an absolute right and need when I'm questioning the jurors in phase one, even though we're not yet in phase two, to make sure that the jurors are comfortable in awarding punitive damages. So you really have to take your time in voir dire to discuss the idea of punitive damages and what the jurors' views are on that element of damage. Because if they say we could never award punitive damages regardless of what the evidence is, that juror, even though they may never get to that point of the trial, cannot sit as a juror in your case because they reject the notion, which by law, you're entitled to recover if the evidence supports it. And so when you would phrase that question to the jurors, you would say, assuming for a moment that the evidence presented to you suggests that there should be punitive damages, that the conduct was despicable conduct, and I'm going to ask you on behalf of my client for an award of punitive damages. If the evidence supports that, and it's important that you say those words because it's got to be based upon what the evidence is. If the evidence supports that, can you award punitive damages? Perfectly fine question, perfectly appropriate in your voir dire of an even bifurcated case. That answer has got to come to you to know whether or not that is a juror you're comfortable with for your client's sake having participate in this trial. And so if a judge says to you, hey, listen, you can't ask that question now because that's for the next phase of the trial, it doesn't work that way because you're only going to have one jury that decides this issue. It's also important not to let the jurors know ever that there's going to be a second phase to the trial because you don't want the jurors to think that by awarding punitive damages that somehow it's going to extend out their jury service. So typically what the judges will do that I've tried cases with, if we're starting trial June 1st and we think the underlying case is going to probably take around 14 days, the judge will ask the juror, are you available to stay till July 1st? The judge, he or she won't tell them there's going to be a multi-phase to the trial, but will clear the entire month of June. So that if there is a finding of liability and punitive damages, you'll be able to have a punitive phase without losing that juror for time constraints. So again, voir dire is an important time to explore these issues and make sure that you build into this the time necessary to get to a punitive phase if you get there. But again, don't point out to the jurors there is going to be another phase to the trial because that might discourage them from awarding punitive damages, and they think it's going to prolong their time to have to sit as a juror in the case. And, I can think of lots of different examples that you want to talk to the jurors about, but you'll want to work with either your jury consultant or just sort of the facts themselves to figure out what questions you want to ask the individual jurors during voir dire to see how they would respond to a certain set of facts that would justify, if appropriate, an imposition of punitive damages in this case. And then you want to look at sort of And this goes to what is oftentimes called the reptile approach. I don't use reptile when I try my cases, but it's the idea of violating the law. This is a simplification of it, but if you violate the norms, you violate the law in terms of just community impact on what you've done, and whether or not the jurors are comfortable with awarding damages if someone has violated that community standard, which would essentially be hopefully despicable conduct that would allow you to get that punitive award from the particular defendant. And then you constantly want to really emphasize for the jury that the behavior of the defendant or defendants in this case really is outrageous, is despicable. You want to kind of use those words if you can to just frame the behavior of the defendant. So if there's a question that their conduct in fact did not violate the standards, by using those standards in the questions that you're asking and framing it that way, both in voir dire when you're looking to pick the jury and as you're putting the evidence on, will help support the court's comfort level in hopefully sustaining your award of punitive damages that you get from that trier of fact. So throughout the course of the trial, you want to create the themes that continue to get the jurors focused on the defendant's behavior, either through the witnesses that are testifying or the evidence that you're going to be presenting to the jury. Constantly put that thread together, because that thread will tie in all of the different elements of the case necessary for you to ultimately really hold on to an award of punitive damages that the jury awards you.
Right, and what I will say here too is Paul does a really good job when he presents evidence. Sometimes it's very scientific or nuanced material and long chains of emails. But I think what Paul does is really at trial, he's able to synthesize the story so that the jurors understand what happened in a very simple way, that the jurors understand, okay, well, this plaintiff was harmed and it's because of a series of the defendant's bad acts. And I think through Paul's presentation, he really gets the jurors on his side almost, because he's telling a story, he's direct, he's straightforward about the facts. So Paul, do you want to talk about anything about how you present to the jury in terms of the storytelling and making sure it's relatable?
Well, I think ultimately there's lots of ways to do this. One of the ways I like best, honestly, is doing a focus group, because focus groups, taking ordinary potential jurors together in a group to discuss the facts of the case, is very, very powerful in helping you understand how to frame the issues you're going to present to the jury. In almost every trial I've done recently, we've done focus groups with either virtual or in person to really gauge jurors' responses to the issues that are presented to them. And it's so critical because, quite frankly, a number of times jurors pick up on themes and look at issues of evidence that we didn't even pay attention to. There might be a photograph that has something in the picture that we never even looked at before. And when these focus group jurors did, we're like, oh my God, how did we miss that? So you're able to really play out your themes with potential jurors in advance of the trial to really get a sense of what works, what doesn't work, and how to frame the issues themselves, right? Mel?
Right, exactly. And I think Paul's favorite jury consultant is his wife, right? Because you always practice your opening and she'll tell you. And that's what I do too with even with my spouse, trying to explain what the issue is. And he'll quickly tell me, well, I don't know, it's not really making sense. So I have to retweak. And I think Paul's wife, Dana, does something similar.
Dana's my top. I would not have Dana as my juror. To be clear, she would not be on one of my panels. She would not be. And she's listening to, she'd agree. But it's good to have individuals. You don't, like, your office is a good place to have ideas passed around. Not a good idea is to use as a focus group. You need to have really independent thoughts shared with you in a way that you can rely on, as opposed to people are just maybe saying to you what they want to hear, what you want to hear. Want to talk about KC 3940?
Sure. So just with the jury instructions, I mean, these jury instructions are very straightforward, right? The series that you want to focus on is the 3940 series. Really, again, you're just emphasizing the clear and convincing burden, how it's been established, and really connect the legal language to your theme that you've developed throughout the trial.
And what I'd like to do here is I always have the jury instruction presented to the jury. Either I use typically an iPad, and we're using wireless connection to the screen, either a TV or a projector, and discuss the clear and convincing standard, and then show how the evidence that you presented so far establishes the clear and convincing proof that you need to show. So what you're doing here is two things. Number one, showing to the jury why they should award punitive damages to you. And number two, creating a record. So the court, first, the trial judge, when he hears the inevitable motion for new trial, or the appellate court, who hears the inevitable appeal, why you've met the standards of the case instruction by taking the jurors through that and showing the facts that support the jurors' findings.
Closing arguments.
Well, here's the thing. If you have a really good case and you want to maximize your compensatory damages, which are easier to hang on to than punitive damages, I don't disagree with the Court of Appeal and the Supreme Court's decision that jurors tend to increase the amount of general damages where there's punitive conduct that has occurred. And I guess the Dennis case in Roundup is a pretty good example of the jury awarded $7 million in non-economic damages, which was a substantial recovery for this individual's claims, and yet gave $325 million on top of that for the punitive damages award. So by really tailoring your claims for your client to the jury in your closing arguments, you will likely enhance your total economic and non-economic damage recovery, which at the end of the day is going to be a whole lot easier to hang on to, bottom line, than punitive damages are. I rarely view punitive damages as much of an incentive to ultimately force the defendant to pay more. They might on the underlying damages that you're asking for. It's more like an opportunity to get something in addition to your special and general damages, but I would rather hold on to those damages by having a reasonable punitive award. So, but for example, on a 1-to-1 ratio, I would rather the jury potentially award me $7 million in underlying general and special damages, and then $7 million in punitive damages, because that shows that the jury wasn't acting out of passion, prejudice, or sympathy. It's a reasonable 1-to-1 ratio. And you sustain your $7 million underlying recovery versus the $7 million in punitive recovery that you might receive, but will ultimately be challenged. The closer it is to 1-to-1, the greater the reliability is that the Court of Appeal will hold on to that verdict at the end of the day. Not to say it doesn't happen, that you're asking for substantial punitive damages, but having a closer ratio further supports your ability to keep that element of damage that you recover. One point, though, it's important to note. Punitive damages are totally taxable to your client. So, for example, if it was a $10 million punitive award and your attorney's fees hypothetically were 40%. But if the jury awarded $10 million, your client would be taxed on $10 million, not on $6 million, but would be taxed on $10 million. So the client would pay you $4 million in fees. Your client would then have to pay taxes on $10 million. So that's $5 million hypothetically in taxes. So at the end of the day, on a $10 million award of punitive damages, your client might only actually recover net $1 million, really, at the end of the day. Punitive damages play a heavy burden on the plaintiff potentially in receiving that recovery if it were to be paid. That was a mouthful.
No, so it's a very, very important point. And I think this goes to the basis of our whole presentation is how we keep our punitive damages. What's reasonable, what we need to establish. Would we love a $325 million punitive damage award? Of course. But is that going to be upheld? Even with the most egregious conduct and an established record, we've seen that time and time again, punitive damage awards are cut down. And to what ultimate benefit to our clients? So these are all very important considerations.
We're almost 2 minutes from the end, so keep going.
Yeah, well, we do only have 2 more minutes, so I'm happy. Paul, there are common pitfalls and final tips if you want to give, and then we can open up to questions.
Well, if we have some questions, maybe I think there may have been a few that came in. It might be tough to get into the others. Let's see. Nickerson. Is that a personal injury case, Nickerson versus Stonebridge? I don't recall what the Nickerson underlying case was.
Let me pull that up really quickly.
And Elizabeth will get to the answer in 2 seconds.
Yeah.
And meanwhile, Paul Levine asks, I have a default entered against a corporate defendant and its individual owners. Do I still have to show their financial condition? If so, how can I conduct discovery under 3295? And the answer is you should not. If the court has found, in my view, that the default judgment that you're seeking to enter is appropriate, that's the judgment piece of it. The judge may not enter a judgment of that amount of money. She may require you to. But I had a case where a Learjet fell out of the sky when there was a problem with the maintenance of the aircraft. And I believe the judge gave us a default judgment of over $75 million based upon the record of underlying damages without having to go through a 3295 analysis. The judge entered that order and entered a judgment against the defendant for that amount of money without having to go through those steps. Mel?
Going back to Nickerson, Nickerson was actually a bad faith claim. It's against an insurance provider.
Good.
Yeah. I can give you the site if you want it. It is 63 Cal 4 363.
Perfect. And it is now 1:30 on the nose. So well done, Mel. Thank you for the time. Beverly Hills Bar, thanks for giving us a chance to spend lunch with y'all. And we're out. Thanks all.
Thank you very much.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.